Hi, I'm Lisa Burton Crawford, and this is a lecture about the constitutional significance of statutory interpretation. Now, the very first point to make is that there is now a lot more legislation than there used to be. This picture provides just a very rough snapshot of the way that the rate of legislative activity and volume of legislation has increased over time. So we have on the left a compilation of all the statutes enacted by the Australian Parliament in 1921. And then we have the compilations of all the statutes enacted by the Australian Parliament in 1961. And then we have the compilations of all the statutes enacted by the Federal Parliament of Australia in 2001. So we can see quite clearly how the rate of legislating has increased over time. That leads us to the first of four key points that I'm hoping you took out of the readings for this topic. The first is that statutes must be interpreted as part and parcel of the core judicial function of ascertaining the content of the law in order to resolve legal disputes. In our constitutional system, that is one of the core roles of the courts, to decide disagreements about the meaning and application of the law when they arise. And given the ubiquity of legislation, very few legal disputes could now be resolved without needing to interpret a statute. The second and related point is that courts will need to interpret legislation in order to perform their important functions of constitutional and administrative review. So by constitutional review, we mean checking to see if a statute enacted by a parliament is within the constitutional boundaries of its power. And that will depend upon what the statute means, what the statute does. Administrative review means the review of executive action. And a core component of that is ascertaining whether the executive officer has acted within the boundaries of the power conferred by legislation. So again, you can see that in order to do that, it is crucial for the court to figure out what the statute says. The third key point relating to the court's role in interpreting legislation and how that relates to the other branches of government is that it is Parliament's job to make legislation, not the courts. So we know that there is no strict separation of powers between the legislative and executive branch in the Australian system of government. Parliament can delegate legislative power to the executive branch, and the executive makes legislation in the form of regulations frequently. But it's generally said that the court's role is far more restricted to what we call interpretation. And that is generally explained as figuring out the meaning contained in the statute that Parliament has chosen to enact as law. It does not extend to making choices as to what the content of the statute should be, or in other words, rewriting the statute. That is said to be beyond the power of the courts and solely the responsibility of the Parliament. But as you see discussed in your readings, that constitutional picture and the relationship between the branches of government is complicated by the fact that courts interpret legislation, and they interpret legislation in light of rules that they make. Now, Parliament can enact rules of statutory interpretation. It has done so extensively. The Acts Interpretation Act at the Commonwealth level and at the state levels being our primary example of that. But many of our most important rules of statutory interpretation are rules of common law. Courts created them. So what we have is a constitutional picture in which it is Parliament's job to make statute law. But once Parliament has performed that function, the legislation is then out of its hands and it falls to the courts to ascertain what it means. Now, Justice Baston has really captured what that means for our understanding of the individual rules of statutory interpretation in a quote that I've extracted for you here. And as Justice Baston says, it's a constitutional rule, a fundamental one, that legislation has primacy over judge-made law. And while courts can read legislation in accordance with interpretive rules that they create, those interpretive rules demand justification if the courts are not to be seen to exceed their constitutional role. In other words, while the courts can make interpretive rules to assist them in their interpretive tasks, those interpretive rules can't really have the effect of changing the meaning of legislation, because then we upset the constitutional distribution of powers. Now, as you will see discussed in your readings, historically courts tackled this problem by saying that they would interpret legislation in order to give effect to the intentions of the enacting parliament. And all the various rules of statutory interpretation were justified as tools for serving this broader purpose. And that orthodoxy is captured in this quote from an article by Richard Eakins and Geoffrey Goldsworthy that I've extracted for you here. But more recently, that orthodox explanation has been questioned. The reasons for that are complex and we don't need to go into them in detail, but in a nutshell, the idea is it's difficult to understand how a complex group of individuals like Parliament can form an intention. What does it mean to say a large body made up of a large group of individuals with very different personal views, agendas, and so forth has formed an intention? So for those reasons, the High Court has offered a more nuanced and slightly different picture to the one that we see conveyed here. This is a passage from the case of Zeng and Kai that's extracted in your readings for this topic. And here you see the High Court referring to the fact that the rules of statutory interpretation have been developed by the courts over time, and they reflect that constitutional distribution of power and the fact it's for the courts to develop interpretive rules. And they gain legitimacy from the fact that they are known and accepted by all arms of government. So these principles of statutory interpretation become effectively the rules of the interpretive game. And Parliament knows that if it wants to achieve certain objectives, it has to draft legislation that will be interpreted the way it wants it to be in light of those rules. And here we see Justice Gageler saying that even if the concept of parliamentary intention has a fictional dimension, in the sense that we can't really say that a large and complex group of individuals forms one intention, it's still an important concept. And it's important because it contains a message for judges about judging. What I think His Honour is saying here is that by telling themselves that the object of statutory interpretation is to give effect to Parliament's intention, courts are always reminding themselves of that fundamental constitutional rule, that it's Parliament's job to decide what should be enacted as law and not theirs, or, as Justice Baston put it, that legislation has primacy over judge-made law. So that returns us full circle to our 4 key principles about the constitutional significance of statutory interpretation. 1, it is an absolutely indispensable part of the core judicial function of resolving disputes about the law. 2, it will play an important part in constitutional review and administrative review. 3, it is Parliament's job to make statutes, not the courts, but we have a complexity there because it is the court's job to make the rules which govern the interpretation of legislation, unless and insofar as we find guidance in acts, interpretations, acts, and legislation of that kind. And in performing that function, courts always have to have regard to the constitutional boundaries of their interpretive power.